The Supreme Court of India today resumed hearing a significant writ petition filed by the Kerala government in 2023, challenging the prolonged delays by the then Kerala Governor Arif Mohammed Khan in granting assent to bills passed by the state legislature. The case, which raises critical questions about gubernatorial overreach and the constitutional balance between state legislatures and governors, underscores an ongoing tension between opposition-ruled states and their governors, who are appointed by the central government. The hearing, scheduled for further deliberation on May 6, 2025, is poised to address the broader issue of whether governors can indefinitely delay legislative processes, potentially undermining democratic governance. The Kerala government's plea, filed under Article 32 of the Constitution, stems from what it describes as manifestly arbitrary inaction by Governor Arif Mohammed Khan, who, as of November 2023, had kept 8 key bills pending for periods ranging from 8 to 23 months. These bills, which included the University Laws Amendment Bills, the Kerala Cooperative Societies Amendment Bill, and the Kerala Lokayukta Amendment Bill, were deemed critical for public welfare, addressing issues like university governance, cooperative sector reforms, and anti-corruption measures. The state argued that the governor's failure to act promptly violated Articles 14, Right to Equality, and 21, Right to Life, by denying citizens the benefits of welfare legislation. Article 200 of the Constitution mandates that when a bill is presented to a governor, they must either assent to it, withhold assent, return it for reconsideration with a message, or reserve it for the President's consideration as soon as possible. The phrase "as soon as possible" has been a focal point of contention, as the Constitution does not specify a timeline, leading to varying interpretations of gubernatorial discretion. The Kerala government contended that indefinite delays were not only arbitrary, but also subverted the democratic will of the elected legislature, effectively stalling governance. The Supreme Court's involvement began in November 2023, when a bench led by then Chief Justice D.Y. Chandrachud issued notices to the Centre, the Kerala Governor's Office, and the Union of India, seeking responses to the state's allegations. During these early hearings, Senior Advocate K.K. Venugopal, representing Kerala, argued that the governor, as part of the state legislature under Article 168, could not act contrary to the elected representatives' wishes. He highlighted that some bills had been pending for over 2 years, with no justification provided by the governor. Developments in the case. By the November 29, 2023 hearing, the court noted that Governor Khan had taken action on the pending bills after the issuance of notices, assenting to one bill, the Kerala Private Forest Bill, and referring 7 others to President Draupadi Murmu for consideration. However, the state challenged the referral, arguing that the governor failed to provide reasons linked to constitutional provisions, such as inconsistencies with central laws under Article 254, or encroachment into the union list. The court, led by CJI Chandrachud, expressed concern over the governor's conduct, questioning what was the governor doing for 2 years on these bills, and noting that such delays could not be used to thwart the normal process of democratic lawmaking. The Kerala government further escalated the matter in March 2024, filing another plea against President Murmu for withholding assent to 4 of the 7 referred bills without disclosing reasons, calling the action arbitrary and a violation of Articles 14, 200, and 201. The state argued that these bills, which dealt with state-specific matters like university governance and cooperative societies, did not require presidential intervention, as they did not impinge on center-state relations. This move highlighted the layered complexity of the dispute, involving not just the governor but also the central executive. Recent hearing and current status. On April 22, 2025, the Supreme Court, presided over by Justices P.S. Narasimha and Joymalya Bagchi, heard arguments on whether a recent judgment in a similar case involving Tamil Nadu's governor applied to Kerala. On April 8, 2025, the court had ruled that Tamil Nadu Governor R.N. Ravi's delay in assenting to 10 repassed bills was illegal and arbitrary, setting a precedent with specific timelines. Governors must decide on bills within 1 to 3 months, depending on the action, assent, withholding, or referral, and judicial review could be invoked for non-compliance. Senior Advocate K.K. Venugopal argued that this ruling, binding under Article 141, should apply to Kerala, as the issues of gubernatorial delay were analogous. However, the centre, represented by Attorney General R. Venkataramani and Solicitor General Tushar Mehta, contended that the Tamil Nadu judgment did not cover Kerala's case, citing differences in factual circumstances. Mehta requested an adjournment to study the Tamil Nadu ruling, suggesting that Kerala's plea required detailed arguments. The court scheduled the next hearing for May 6, 2025, to examine whether the Tamil Nadu precedent applies and to address the broader constitutional question of gubernatorial powers under Article 200. The Kerala government, represented by Venugopal and Advocate C.K. Sasi, has consistently pushed for the court to establish clear guidelines on when governors can refuse assent or refer bills to the president. Venugopal has argued that the lack of such guidelines creates confusion in the minds of various governors across India, leading to systemic delays in opposition-ruled states like Kerala, Tamil Nadu, Punjab, and Telangana. Constitutional and political implications. The Kerala case is emblematic of a broader trend of friction between opposition-ruled states and governors, who are often perceived as acting at the behest of the central government. Similar disputes have arisen in Tamil Nadu, where Governor R.N. Ravi was accused of positioning himself as a political rival to the state government, and in Punjab and Telangana, where governors delayed assent to critical bills, prompting Supreme Court intervention. The court's observations in these cases, including its April 2025 Tamil Nadu ruling, emphasized that governors must act within the constitutional ethos and not reduce state legislation to mere pieces of paper by indefinite delays. Critically, the case raises questions about the role of the governor in India's federal structure. Governors appointed by the president on the centre's advice are meant to serve as a constitutional link between the union and the states. However, their discretionary powers under Article 200 have been contentious, especially when exercised in ways that appear to obstruct state legislatures. The Kerala government's plea argues that such actions disrupt the federal balance, rendering the elected executive and legislature wholly ineffective. On the other hand, governors like Arif Mohammed Khan have defended their actions by citing concerns over the legality or clarity of bills. For instance, Khan expressed reservations about the Kerala Cooperative Societies Amendment Bill, linked to the Karuvannur Bank scam, and the Lokayukta Amendment Bill, which shifts appellate powers from the governor to the Legislative Assembly. These concerns suggest a genuine exercise of discretion, but the lack of timely action or transparent reasoning has fueled accusations of political bias. The current Kerala Governor Rajendra Vishwanath Arlekar, who succeeded Khan in January 2025, has taken a different stance, claiming no bills are pending at Raj Bhavan, and describing his relationship with Chief Minister Pinarayi Vijayan as cordial. However, Arlekar's recent criticism of the Supreme Court's Tamil Nadu ruling as judicial overreach sparked a sharp rebuttal from Vijayan, who called the remarks unacceptable and politically motivated. This exchange underscores the ongoing sensitivity of the governor's role in Kerala's political landscape. Broader context and critical analysis. The Kerala case is not an isolated incident, but part of a pattern where governors in opposition-ruled states have been accused of delaying or obstructing legislation. The Supreme Court's interventions in Tamil Nadu, Punjab, and Telangana suggest a growing judicial impatience with such conduct. In November 2023, the court referenced its Punjab ruling, which held that governors cannot virtually veto bills and must return them for reconsideration if assent is withheld. This principle, reinforced in the Tamil Nadu judgment, could shape the Kerala case's outcome. However, the centre's argument that each state's case is factually distinct raises a valid point. Blanket timelines may not account for the complexity of individual bills or gubernatorial duties. For instance, bills involving significant legal or financial implications, like those amending university laws or cooperative regulations, may require thorough scrutiny. Yet, the absence of reasons for delays or referrals as seen in Kerala undermines transparency and fuels perceptions of partisan interference. From a critical perspective, the narrative of gubernatorial overreach must be balanced against the constitutional design. Governors are not merely ceremonial figures, but have a duty to ensure that state legislation aligns with constitutional norms. However, when this duty is exercised in a manner that appears to prioritize political alignment with the center over state interests, it risks eroding federalism. The Supreme Court's role in setting timelines and guidelines could clarify these boundaries, but also raises questions about judicial overreach, as Arlekar argued. Amending constitutional provisions through judicial interpretation, without parliamentary consensus, could set a precedent that challenges the separation of powers. As the Supreme Court prepares for the May 6, 2025 hearing, the Kerala case could have far-reaching implications for center-state relations and the governor's role in India's democracy. A ruling that applies the Tamil Nadu precedent would establish a uniform standard for gubernatorial action, potentially curbing delays across states. Conversely, a narrower ruling could leave room for case-by-case discretion, preserving some gubernatorial autonomy but risking continued disputes. For Kerala, the outcome will determine whether its legislative agenda, including welfare measures and institutional reforms, can proceed without external bottlenecks. The state's persistence in challenging both the governor and the president reflects a broader assertion of state autonomy in a federal system increasingly marked by centralization. The case also highlights the need for constitutional clarity on Article 200. While the Supreme Court's guidelines could provide temporary relief, a long-term solution may require legislative or constitutional amendments to define timelines and criteria for gubernatorial action. Until then, the tension between state legislatures and governors is likely to persist, with the judiciary serving as the arbiter of India's federal balance. Disclaimer: this article is based on information from web sources and posts on X, which may not be exhaustive. Readers are encouraged to verify details with official court records or reputable news outlets for the most accurate and up-to-date information.